Yes, thank you. Your Honor, the only reason that I came into proper possession of the weapon is my mother passed away in July of this year. All of her personal effects fell to me. Prior to that, I've never been a gun owner in my life, never wanted to be a gun owner. And, I didn't use the weapon in any kind of assault or robbery sense or anything. I only kept it with me because my house had been broken into twice.
Court is calling 2024 CR 0061, State of Texas versus Larry Holmes. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense,
George Schaefer for defendant Larry Holmes, Your Honor.
are you Mr. Holmes?
Yes, I'm Larry Holmes. How you doing, Your Honor?
Oh, I'm doing great. Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Holmes, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you,
Yes, I did, Your Honor.
and did you sign it?
Yes, I did.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are here.
Counts 1 and counts 2? I think you waived number
I
2.
think he waived number 2.
Sorry about that, Judge. Yes, ma'am. We're waiving count 2.
Any objection?
No, Your Honor.
Showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unlawfully carrying a weapon with a felony conviction?
Yes, Your Honor.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Holmes, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's to be a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2024 CR 3061. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Could I see that file, please? Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 120 hours of community service restitution, and no contact with Super Walmart. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1, how do you plead?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objection?
No, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes,
Did
Your
you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? I found it. A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we would like to, yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, this was just a bad day. Excuse me, at the store, he got into an argument with someone. He was asked to leave the store. He was leaving. And at that point, the police initiated a search of his person and his property and found the gun. It's an antique gun, belongs to the family. And he's asked that one of his brothers who's licensed to carry be allowed to retrieve the gun at some point. I told him I'll help him with that.
Okay.
Yes, thank you. Your Honor, the only reason that I came into proper possession of the weapon is my mother passed away in July of this year. All of her personal effects fell to me. Prior to that, I've never been a gun owner in my life, never wanted to be a gun owner. And, I didn't use the weapon in any kind of assault or robbery sense or anything. I only kept it with me because my house had been broken into twice. It's not an excuse, but it is an explanation for why I had the gun on me in the first place. Aside from that, I'm not a gun owner and I don't have any violent crimes in my past.
I'm sorry, just one moment.
Getting back to your original question, yes, we'd like to proceed to sentencing.
All right, thank you. Contractors. All right, anything you wish to say on behalf of your client?
Already said it.
Okay, no, anything else
No.
based upon what he said?
No.
All right, so have you ever had any drug issues?
Oh.
Here's the thing, you need to be honest, because I've read the police report.
Yeah, I mean, yeah.
Okay. All right, this is what the court is going to do. Sentence you to a $1,500 fine probated. There's to be no contact with Super Walmart or Walmart. 6 years deferred adjudication. Proof of employment within 45 days of release. There's to be no employment as a home healthcare provider with minors. Take in consideration 2024 3061. There should be anger management classes. Felony drug court referral and custody. Be honest with felony drug court, you understand?
Yes, sir.
TAP evaluation in custody. There's to be 120 hours community service restitution, regular reporting by Zoom or in person, regular random UAs, field visits, one time per month for 3 months. Do you have any children?
No, Your Honor.
Okay. Probation, is there anything else? Is there anything else you need from the court to be successful? The felony drug court, that should be done by this week because it's a Monday. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand when people go to a place, you pay for something with cash and you want your money back. And they're telling you all they will give you is a gift card. Guess what? That's what Walmart's policy is. All they're going to give you back is a gift card. And now they've changed it. It used to be if you show them a receipt, they'll give you cash. But they don't even do that anymore. Everything is you'll get it back on a gift card. All right. Good luck to you.
The hearing hinges on a stark contrast. Defense witness David Huffman, the defendant's mother, paints a picture of a nonviolent son corrupted by addiction and homelessness. Through tears, she describes reclaiming her loving son during his incarceration and offers a full support system in Florida, a home, a job, a fresh start away from old influences. Her testimony is a heartfelt plea for deferred adjudication and probation. Then, the state systematically dismantles this narrative. The prosecutor forces the mother to confront the gruesome reality she claims ignorance of. The victim was beaten, lost an eye, had his skull crushed, was shot and stabbed, then hogtied and dumped nearly naked on the side of the road. The mother's shaken responses reveal a painful disconnect between the son she wants to believe in and the perpetrator of a savage crime. Judge Stephanie Boyd enters this chasm. Her questions are razor sharp, cutting through the emotional appeal to the hard facts of the pre-sentence investigation. She highlights the defendant's own prior statements denying drug use during the offense, directly contradicting the drug-induced defense. Judge Boyd's demeanor shifts from listening to unequivocal authority. She articulates the paramount duty to protect the community from such violence, stating that the extreme nature of the crime demonstrates a clear and profound danger. In her final ruling, Judge Boyd destroys any notion of a simple second chance. She grants probation, but under the strictest possible terms, likely spanning a decade. She orders his removal to Florida, not as a reward, but as a form of controlled deportation from his old environment. She mandates GPS monitoring, treating him as a flight risk and a potential danger. Every condition is a shackle of accountability. Judge Boyd transforms the mother's offer of help into a framework of severe, supervised correction, making it unequivocally clear that the gravity of his actions has permanently altered the course of his life under the unblinking eye of the law.